has also sent a notice to the railways and the Uttarakhand government. In his first reaction, the Uttarakhand Chief Minister Pushkar Dhami said that we are going to abide by the Supreme Court's ruling.
देखिए, उस प्रकरण में हमने पहले ही कहा था, क्योंकि वो रेलवे की भूमि है और रेल विभाग माननीय हाई कोर्ट में और माननीय उच्च न्यायालय में जो भी उनका मुकदमा था वो चल रहा था। और राज्य सरकार की तरफ से हमने पहले ही कहा है कि जो भी न्यायालय का आदेश होगा हम उसके अनुरूप आगे कार्रवाई करेंगे।
आदेश पालन किया जाएगा. That is what is being said by the Chief Minister. Straight away going across to Nilashish, who was getting us those live updates from inside the court there. Just get us those live reactions as well, Nilashish.
Well, absolutely. Sanpreet Singh is with me, a lawyer for the petitioners. First and foremost, court definitely staying the matter and also saying that people who are living there for 50 years, over 50 years, you cannot remove them in 7 days.
There has to be some rehabilitation program. This was the word from the court. And yes, the court has absolutely stayed the orders of the High Court directing eviction within 7 days by use of paramilitary force. The court also took exception of the fact that there has been a policy of the state government and certain people have also been given lease rights over the land. You cannot one day during the pendency of the proceedings under the PP Act straight away pass such a direction in exercise of public interest litigation.
Also, the court was questioning how much land actually belongs to the railways and how much portion is belonging to the state. So there is confusion regarding that also.
Yeah, if we see the first round of litigation, there is an affidavit by the state government saying that it's the land of the state government, not the railways. So as of now, it is not very much clear that which portion of the land belongs to railway and which portion of the land belongs to the state government.
Very significant, and they're all right to rehabilitate these people.
If we see the prayer made in the public interest litigation, which was actually filed before the High Court, the very prayer was to start with the rehabilitation. Even the writ petitioner before the High Court was contending that prior to their eviction, there must be some rehabilitation program. So it's wrong to say that there was no such prayer before the High Court. Even otherwise, there are certain other proceedings also, the indulgence of which was shown to the court, was also brought to the notice of the court, that a petition in seeking rehabilitation, there has been a notice from the High Court.
Final question, the court has agreed that this is a human issue as well. There's a human angle, but also it is an issue that is very significant and important to the railways.
Yeah, that's correct. There has to be some sustainable development. But prior to that, this has to be ascertained whether the land belongs to railway or not. You cannot one fine day come and say that you evict from this land without there being any deliberations that whether this property belongs to whom.
Thank you so much. So you can hear the lawyers there saying clearly that this is a relief, and now as the matter moves forward and comes up after a month's time, the stand of the railways as well as the state of Uttarakhand will be more clear.
Okay, all right. Nilashish, thank you for getting us that update. Also want to introduce Senior Supreme Court Advocate Swapnil Kothari and Priyanka Tibrawal on the broadcast with us. Mr. Swapnil Kothari, first want to ask you, the Supreme Court says Uttarakhand High Court's order for Haldwani eviction has been stayed, but the proceedings under Public Premises Eviction Act is going to continue. If you can put that in perspective and explain how things will work out now.
Well, the Public Premises Eviction Act is a separate legislation in the sense that it talks about illegal encroachment on any public premises. Obviously, this is a public premise here because it's a railway land, as claimed by the railway authorities. I don't for a moment doubt that it is a railway land, because the Uttarakhand High Court has gone into the absolute details and the nitty-gritty of the entire issue and has come to a conclusion that yes, it was a railway land. And it came across and it came with a 176-page order saying that yes, this needs to be demolished, this encroachment. Now, what the Supreme Court has done is, at the interim stage, it usually when it comes across and when it faces this kind of a thing, obviously they could have argued, but there was a stay and interim relief that was prayed for by the petitioners that, look, 7 days is too short a time. We need some time on our hands. So the petitioners' advocates have not gone in to challenge the High Court order as much as they went in right now at this stage for some sort of a stay, which they successfully got. The reason why did they get? Because the Supreme Court or any other court of law, when it approaches any issue at an interim stage, it applies the doctrine of balance of convenience. Who is going to be more inconvenienced with an order if we confirm it? Now, obviously, if the Supreme Court would have said, yes, go ahead with the demolition within 7 days, overnight, the people who would have been inconvenienced would have been those 50,000 people who are living in that particular area. Obviously, they've been living since about 40, 50 years. So it's the balance of convenience lies in favor of the petitioners, not in the favor of the railway land.
All right.
Railway land has not been developed for another...
No, but that's also a point that is also being raised here by the court. Swapnil, please to stay on with us. Mr. Subhash Rai is also joining us here on the broadcast. Good afternoon. Priyanka, I would want to hear from you on this. Does it mean that no bulldozers, no demolition that can take place for now in regard to the temporary relief? Because the Supreme Court has said that they have stayed only, clarified, saying that the High Court order of December 2022, that has been said, the proceedings will continue.
See, I will speak in the tune of what Mr. Swapnil just said, that the doctrine of balance and convenience. See, this is just an interim relief, a stay for the time being. This is the observations, whatever observations of the Supreme Court we've heard on humanitarian grounds. So these are just observations, not judgments. But we also have to look into the fact that, there has to be applicability of law. So that is why I'm saying that this is just an interim relief. When the matter will be heard at length, then the applicability of law will be used, and they will see whether this illegal encroachment, whether at all, if this is an illegal encroachment, whether these people who are staying there, whether they are illegal immigrants or not, that has to be taken into account. And if at all they are citizens of India, then I think humanitarian ground also works, and then they should look forward to some kind of rehabilitation. But if they are not at all allowed, if they are illegally proved to be encroachers and immigrants, like I said, then as per the law of the land, things should take place. So like I said, that the order which has been passed today is an interim relief. It's a stay for the time being.
Okay, so Mr. Subhash, would you also say the same? What do you think is the key takeaway of what the Supreme Court has said today? Because it did say that we want to look at a solution, time and again saying that that we are stressing on a solution to the problem.
See, it is so shocking that 29 acres of railway land in Haldwani has been encroached and must have been encroached over a period of time. In every encroachment cases, those who practices law in the court would agree with me that the defense always is that, look here, we have been, although they might be staying there for 4, 5, 6 years, they may claim that they are staying there for last 50 years, 60 years. Merely because you stay illegally, occupy a premises, that does not give you any right in law to hold on to the property indefinitely. Now, assuming that they were there for 4, 5 years, 6 years, or maybe 2 years or 1 year, I mean, the action needs to be taken also against those erring personnel of what RPF has been doing. And what railway authorities have been doing all these years.
So that blame game has been ongoing, and in fact it has gone to such an extent that communal spin has also been given to the kind of blame game that we have been seeing, that who actually erred, who is actually to be blamed. That is where we are seeing how the protesters versus the government versus the courts, that is the current situation playing out. For now, it's a temporary relief. We'll focus more on the story. Thanking our guests. We'll be back after a short break.